Hi, good morning, everyone. This is Rajeshkumar. Today, we are going to analyze one problem question on offer and acceptance. Disclaimer: the video content has been made available for informational and educational purposes only. Kindly go through the disclaimer completely. Let's start with the problem question. Isaac owned a shop selling the fishing supplies. He placed an advertisement in his shop window. Five handmade fishing rods for sale, each £1,000, available only to the first five people who pay me this amount by Saturday, 1st of May. In his window, he also displays a box containing 10 fishing knives. The box has a sticker on it which reads handmade knives, £200 each. Devi sent Isaac £1,000 in the post on Tuesday, 27th April, and says she will collect the rod on Monday, 3rd May. The letter gets lost in the post. On Thursday, 29th April, Charles telephones Isaac and asks if he can buy two rods for £1,500. Isaac says he wants to think about Charles' offer. Later that day, Isaac telephones Charles and leaves a message saying, I'm happy to sell you two rods, but the price must be £1,700. On 30th April, when Isaac does not hear from Charles or receive any other offers for the rods, he places a notice in his shop window stating that the handmade rods have been withdrawn from sale. On 1st May, Charles goes to Isaac's shop with £1,700. He's in a rush. She does not read the notice in the window and asks for two rods for 1,700, which Isaac declines. Charles says, okay, I will give you the £200, but Isaac explains the rods are no longer for sale and point to the notice in his window. At the same time, Bronwyn enters the shop to buy a knife. Isaac explains that he now realizes that it was illegal to sell the kind of knives he has in his window, and so refuses to sell one to Browning. We have to advise Isaac. We have to analyze the Isaac scenario under the contract law principle of offer and acceptance. We have to first differentiate between the potential contracts regarding the rods and the knives. Fishing rods, Isaac advertisement. Isaac placed an advertisement stating that five handmade fishing rods were for sale at £1,000 each, available only to the first five who pay by May 1st. Based on the Fisher versus Bell 1961 and Partridge versus Clinton 1968, this advertisement constitutes an invitation to treat. It's not an offer. An invitation to treat is merely an invitation to enter into negotiations rather than a binding offer. Therefore, it does not obligate Isaac to sell the rods simply because someone expresses interest or send money. What is the impact of Davis' letter? Davis sent Isaac £1,000 on 27th of April and indicated she would collect the rod on 3rd of May. Given the postal rule, as per Adams vs. Lindsay in 1818, acceptance is deemed to occur when the letter is posted, not when it is received. However, the issue here is that Isaac never received the letter due to its being lost in the post. Under Household Fire Insurance vs. Grant in 1879, the post rule would still apply and the acceptance would be valid. However, Isaac Isaac has not advertised that the rods were available to anyone posting the money. His invitation to treat require payment in person by May 1st. The postal rule does not apply to invitation to treat, meaning there is no contract was formed with Devi. What about Charles' offer? On April 29, Charles offered to buy two rods for £1,500. Isaac did not accept, but instead made a counter offer for £1,700. Following the principle from Hyde versus Range in 1840, where a counter offer terminates the original offer, Isaac was under no obligation to sell the rods for £1,500 after making his counter offer. So, withdrawal of rods. And 30th April, Isaac posted a notice in his shop window withdrawing the rods from sale. Following Shue versus US in 1875, the withdrawal of an offer can be made through the same medium by which it was communicated. Since the rods were withdrawn through the shop window notice, this is valid revocation of the offer. Even though Charles did not read the notice, the revocation was valid once the notice was displayed. So on May 1st, when Charles attempted to buy the rods for £1,700, Isaac was within his right to refuse, as the rods were no longer for sale. In other words, Davis' £1,000 sent by post on 27th April could imply an acceptance if Isaac advertisement were an offer. However, based on Fisher versus Bell, Isaac window advertisement would typically be interpreted as an invitation to trade, not a binding offer. Thus, Davis' action alone does not form a contract. Furthermore, her payment got lost in the post, which under the postal rule Adams versus Lindsay would generally make acceptance effective once dispatched, but this does not apply without a valid offer. What about Charles' counteroffer? Charles' telephone offer to pay £1,500 for two rounds on 29th April constituted a counteroffer, rejecting the initial invitation and modifying the terms, that is, Hyde versus Wrench. Isaac's subsequent message accepting the £1,700 for two rounds created another counteroffer, leaving no acceptance or binding agreement. When Charles visit on 1st of May with 1700, he fails to read the withdrawal notice. And based on Shreve versus United States, once an offer is withdrawn publicly, the original terms cannot be accepted. So the bilateral, as it requires a reciprocal promises, money for goods. So there is no valid contract for Devi or Charles, as no acceptance occurred prior to Isaac's notice of withdrawal on 30th April. Isaac was therefore within his rights to refuse both transactions. Let's move on to fishing knives. We will analyze it. The knives were displayed in Isaac's window with a sticker stating handmade knives for £200 each. Under Fisher vs. Bell, 1961, the display of goods in a shop window is an invitation to treat. It's not an offer. Therefore, Isaac was not obliged to sell the knives just because a Browning entered the shop to buy one. So, what about the illegal sale of the knives? Isaac later realized that selling the knives was illegal. According to the Court principle in public policy, a contract to sell illegal goods is void. Therefore, even if Browning had attempted to buy a knife, no valid contract could have been formed, as the sale of such goods would be illegal. In other words, Browning's approach to buy a knife is comparable to Fisher versus Bell and Pharmaceutical Society versus Boots, where the display of goods with a price tag constitute an invitation to treat. It's not an offer. Isaac has the discretion to refuse the sale, which he exercised but by noting the knife's illegality. So Isaac's refusal is legally permissible as there was no contract and he identified an illegality which prohibits him from selling the knives. So, to conclude, regarding the rods, Isaac was not contractually obligated to sell to either Devi or Charles. No valid contracts were formed under the principle of offer and acceptance. And Isaac was within his rights to revoke the invitation to treat by placing a withdrawal notice. Regarding the knives, since the sale of these knives was illegal, Isaac could not be legally compelled to sell one to Browning. Thank you.